everyone for still being with us, and I apologize for interrupting the stimulating conversations over coffee. We have been shrinking the time dedicated to the coffee break, but that's because the discussion, the Q&A sessions have been so engaging and so interesting. So it's a balance. I'm sure so most of you were here yesterday as well, but just as a short introduction from my part, my name is Julinda Beqiraj. I'm the Maurice Vogt Senior Fellow in European Law here at the Institute, and in particular at the Bingham Center for the Rule of Law. We have yet another fantastic panel, this time on the engagement with the Venice Commission and how such engagement builds constitutional resilience. We will have perspectives from different countries and some more general considerations as to the role of the Venice Commission more broadly. As before, speakers will have about 15 minutes to present their thoughts and considerations. We will start with Dr. Kushtrim Istrefi. He's an associate professor of human rights law and public international law and substitute member of the Venice Commission. You will have the longer version and the details of the bios online. But I wanted in particular to mention his recent publication on the title is A Compendium to the European Convention on Human Rights, real publication. For those of you who are interested, I think you had the copy, but maybe
I'll put it here in display.
Yes.
This is yeah, it's red, so good for Christmas.
Also, you show the thickness. So over to you.
Thank you very much, Julinda, and to the organizers for putting this event together. Very timely both to celebrate these two institutions, but also to reflect on the works of these two institutions and how they connect, broadly speaking, to rule of law, democracy, and human rights backsliding, not just in the UK, but in Europe and beyond that. My presentation, entitled From Soft Law to Hard Law, the role of the ECHR and EU in enforcing Venice Commission opinions, very much connects to Laurent's yesterday's presentation and looks at how the Venice Commission works, but also how other institutions have contributed to its enforcement. The work on the Venice Commission is very well known, but there is hardly any research on it. And so I will also start a little bit with explaining some of the ways in which the Venice Commission works, to then unwrap how this is enforced through different types of mechanisms and perhaps why. So the Venice Commission is triggered in two ways. They provide solicited and unsolicited advice, I would say. The solicited advice is when a state requests the Venice Commission to issue an opinion on a draft law or constitution. And in that case, the state already invites the Venice Commission to react. And so in these types of engagements, the states are usually very keen to get more feedback and engage and then in the end endorse the opinions of the Venice Commission. Though sometimes states also have their own goals and objectives why they ask the Venice Commission to react. And sometimes it may not go in a direction they would prefer. Perhaps the case of Poland with the restoration of rule of law is one of those examples. But also at times states want to use it to boost the legitimacy vis-a-vis the rest of the the opposition parties and others who may contest certain developments. For example, Spain using it with regards to the amnesty on Catalans and so on. The unsolicited advice is the one where things in a country usually don't go very well, and the country doesn't seek an opinion, but then it is usually the Parliamentary Assembly of the Council of Europe that asks the Venice Commission to issue an opinion on a given issue. And these are typical examples from past situation in Poland, Hungary, but also some other states like France, where we issued an opinion on what is known Article 49 of the French Constitution, which concerns the adoption of laws without the approval of the Parliament. And this was a very contentious issue. So that's just a bit to explain the way in which the Venice Commission works, and then this connects with hopefully with what I'm going to elaborate on its soft and hard law. The Venice Commission opinions, as I said, are largely endorsed, even though they are all non-binding. So states, when you look at the way they respond, both when we do the visits in the countries, but also whenever we adopt an opinion, you have usually a minister of the relevant field, usually Minister of Justice, that comes to Venice and engages in depth with a draft opinion, and then there are follow-ups and so on. So there is a dialogue that happens throughout, and there is that usually leads to more acceptance in this case. What is perhaps in a way less explored is how other institutions use the Venice Commission opinions to either adjudicate on their own cases or do other types of assessments, as was mentioned yesterday, some sort of outsourcing. And this is where it happens a lot. So yesterday, again, I'm connecting to Laurent's presentation. He mentioned that the Venice Commission opinion, Venice Commission has been used 143 times in these rule of law reports. And there is indeed a reason behind that. There's a reason why in these specific reports you see a lot of Venice Commission, but not, for example, the same approach when it comes to the Court of Justice of EU or other EU institutions. So the Venice Commission is often triggered as a result of requests that EU makes in the process of accession for member states. So in assessing the accession process, Venice Commission opinions are essentially there because the EU has asked these countries to ask the Venice Commission, whether you talk about Moldova or Ukraine or Western Balkan countries. The rule of law in these countries is then measured based on this outsourced input. And depending on the Venice Commission opinions, their progress towards the EU is shaped. So, and I argue that this is one of the ways in which these non-binding instruments become part of the acquis, and therefore binding source in the process of accession. There are several cases, and because again, this relates to, most cases are in relation to Eastern Europe before the Venice Commission, so that there's a large number of those that relate to accession. But I will just, for the sake of illustration, pick one of them, and that is the Sejdić and Finci case against Bosnia and Herzegovina, where the court had to deal, the European Court of Human Rights had to deal with a very complex issue of electoral law and electoral and regulation of elections in the Constitution and the Dayton Peace Agreement, because as you may know, there are three constituent people in Bosnia and Herzegovina: the Bosniaks, Serbs, and Croats, that have the right to hold certain positions in parliament and the presidency. And so a Roma and a Jewish minority complained before the European Court of Human Rights. The court found a violation on discrimination. And what is important in this is that this was a very complex political case in looking whether the situation has matured enough to move away from the Dayton Peace Agreement to this practically revisiting the agreement and peace terms that were set up in Dayton in '95. And the court found a violation by extensively replicating earlier opinions of the Venice Commission. So Venice Commission opinions were directly cited by the European Court of Human Rights, but most importantly, the logic of the Venice Commission opinions was essential in the reasoning of the court. The court had to look at whether the situation was ripe. These are the terms used by the court to move towards this different electoral system. And then also looking at whether a state has consented to this kind of transition. And they say, well, you have said that we will, through the Venice Commission, revisit the electoral system. And so you have consented to this. So in a way, it's your fault why you agree to do that, or in a way, your responsibility why you agree to do that. But we have to follow this path. Then what happens in the European Court of Human Rights, which became binding law, became also part of the acquis. So the EU, in relation to Bosnia and Herzegovina, has mentioned explicitly that cases like Sejdić and Finci and aspects addressed there are part of the acquis. So this just tells a story how the Venice opinion is triggered, how it's shaped, and how it migrates to this different, as we call these past 2 days, multi-layered system of human rights. So in my view, these are examples how soft law may become hard law. And it's also a way to explore how dialogue in Council of Europe, and especially in Venice Commission, works. In relation to other member states, so as I said, Moldova, Georgia, Ukraine, Western Balkan countries, this happens every year. There hasn't been, to my knowledge, cases where there's been reforms on appointment of judges or prosecutors, where the EU has not requested states to seek a Venice Commission opinion, and where that has not been then part of the EU assessment in the rule of law progress and accession process. So that illustrates, hopefully, my claim on how the soft law hardens in the process. It's a form of what may appear as a clay becoming gradually into something very stable and hard that becomes binding. And it's also, this dynamic is also works the other way around. So the Venice Commission also reinforces the convention in its opinions. Because in addition to the rule of law checklist, some of the key issues raised there, but also in the rule of law checklist itself, is essentially replicating or reinforcing the European Court of Human Rights standards through its own checklist. So it's also a way of reinforcing the convention through Venice Commission opinions. And so there is this dual way of reinforcement of these obligations. And over time, it becomes less and less known where the standard evolved and how it became hard law. Again, whether it's Venice Commission issuing an opinion and then becoming part of ECHR or acquis and vice versa. So I will, I'm aware of time constraints, and I will try to stop soon, but my main message here is also, I think, as we are struggling to with rule of law backsliding, democracy, and so on, and looking at all these in the previous panel, issues of enforcement, compliance, and so on, I think it's also important to reflect how we can ensure that different regimes within the European system, but also beyond that, reinforce rather than compete with each other. And in my view, the Venice Commission is a good example of that. I'll stop here, and thanks for your attention.
Thank you very much, Kushtrim, also for the timely presentation. Actually, what you said closely resonates with the experience that Albania had in the context of, I am quite familiar with the system in Albania. That's my original, so I'm originally from this country. The experience the country has had in relation to the first undergoing a deep judicial reform, backed by the opinions of the Venice Commission, and then the extent to which the country managed or not to include those opinions into the legislation then was screened by the European Commission in the context of the screening and briefing for the screening meetings in the process of accession. So I have a specific question for you, but I will keep it for later. Our next speaker on the panel will be Viktória Alžbeta Sutórisová. She's completing her PhD at the Masaryk University. She researches on judicial governance, resilience, and rule of law in transitional states. And she's also a legal analyst at the Czech Constitutional Court and civil society collaborator. Over to you.
Can I hold this a little bit closer? Yes. Yes, great. So good morning. It's a pleasure to be here. Beautiful autumn in London. Thank you for the organizers who created this nice platform to discuss. Really timely, as other speakers already mentioned. And also thank you, Kushtrim, for your presentation, because mine will be some sort of practical demonstration of your theoretical research. So what I will be speaking today about is how the standards of judicial governance in Europe were evolved. And that was with a great help of both the Venice Commission and later on the ECtHR. So today I will present a formal paper which talks about the Europeanization of judicial governments, the structural issues which the Euro model had encountered, how the Venice Commission created this model, and how did it later on developed. And then I will put into comparison the work of the Venice Commission and the ECtHR case law, and we will look at dynamics between the two institutions in this regard, and that we can discuss. So just to briefly introduce the Euro model. So at the end of the 90s and start of the millennium, a lot of countries were undergoing judicial transformations and reforms, and they were mostly also connected with the reform of the judicial governance. In this regard, the candidate countries did follow the model which was proposed by the European bodies. Of course, as they were trying to encounter the EU membership, they were negotiating mostly with the European Commission, yet the European Commission did not have enough expertise in the field of judiciary design. So also based on the horizontal agreement, was cooperating with the Council of Europe bodies, and especially the Venice Commission, but also Consultative Council of European Judges and other bodies of Council of Europe. But also the European model was later on developed by the international courts, as I've already mentioned, also the UN, OECE, and later on even by the NGOs, especially the European Network of Judicial Councils, which closely cooperate with the European Commission. So if I would have to describe the Euro model in just several sentences, it would be the single institution with a really strong representation of judges who are governing the judicial branch, mostly with 50% plus judicial representation, great competencies in terms of judicial careers, relocations, budget of the courts, administration, and overall expectations from creating judicial councils in transitional countries was to mostly enhance the judicial independence, but also to improve the transparency, effectiveness, and basically also the public trust in judiciary. If we would have to reflect now, more than 2 decades later, we have seen that this plan did not really work, not only in transitional countries, but also later on in the former democracies, which provided a great inspiration for the European model, especially Italy and Spain. But if I would have to sum up the issues of the institution of the creation of judicial councils in transitional countries, I would have like 3 clusters. First of all, it is the value fragmentations of post-authoritarian judiciaries. Basically said, we can change the institutional model, but the judges stay the same, and a lot of them were still bringing their own mindset from the previous regime. This unfamously resulted in corrupt behavior, patronage, nepotism, revolving doors, and many other issues which we've seen in the CE. Then, when the Euro model was created, it did not think about sufficient safeguards against the political abuse. So judicial councils were of great interest of political power because this was the easiest way how to gain control over the judicial branch, either through the appointment of judges, court packing, disciplinary proceedings, etc. And last but not least, it is the managerial inexperience of members of the judicial councils. Judicial councils are governance bodies, not courts, yet a lot of or most of the judges weren't prepared to bear managerial functions. So this either resulted in professional solidarity and creating, as I said, corrupt behaviors, but also the skepticism of a lot of judges, and in the end, hindered the sustainable development of judicial councils. So in terms of the methods I used for this paper and the follow-up, first of all, I used qualitative content analysis. I analyzed 164 judiciary-related opinions of the Venice Commission from its establishment until the end of the last year. I compared it with the opinions and soft law of other European bodies. And for the purpose of this paper, I focused mainly on 3 areas: the composition of judicial councils, its competencies, and disciplinary powers. Later on, I conducted semi-structured interviews, both with the representatives of the Venice Commission and also stakeholders, which consulted with Venice Commission during the opinion preparation. And after I've done this paper, I was interested to see how does the ECtHR communicate with the Venice Commission and whether it used the standards which were previously set up. So I did conduct the doctrinal analysis of the case law of the ECtHR, and now I'm also thinking about the more so quantitative cross citation analysis. So if we would have to sum up the development of the Euro model in Venice Commission opinions, we are seeing that the Venice Commission still prefers the majoritarian representation of judges, yet after the empirical experience, based with the judicial corporatism, it puts a stronger emphasis on non-judicial members. This does not have to be political representatives, but also representatives of fourth branch of power. In terms of competencies, the Venice Commission still prefer the maximum competencies of the judicial councils, yet does acknowledge that some kind of decentralization is possible. Yet, even though a lot of countries are now setting up the judicial appointment committees, the Venice Commission did not provide any guidelines on the professional qualification of the members who should appoint the judges. And then in terms of disciplinary authority, this is the most divergent between all of the European bodies. The Venice Commission does not insist on the judicial adjudication of the disciplinary proceedings, yet as later on was developed by the ECtHR, is expecting that the judicial councils will bear the responsibility under the Article 6 of the Convention, which turns the judicial councils in the semi-judiciary bodies. The main aim of the research was then to see if we've seen that the empirical experience from the countries was not successful in terms of creating judicial councils. I was curious why does the Venice Commission still insist on this model, and how does the Venice Commission discuss about other alternatives? So after conducting the interviews and also on the analysis of the operation of a Venice Commission, I did come up with several reasons which may contribute to some kind of like path dependency in terms of promotion of judicial councils. First of all, it is the limited knowledge of other alternative models by the members. So the members did acknowledge that the judicial council model has its issue, yet do not know any detailing any other alternatives. This is also connected with the composition of Venice Council, which is still majoritarian represented by judges. We are seeing increasing number of academics, yet as I mentioned before, judges conducting governance political opinions is not in their respect of experience as judges. Then there is also problems with the adoption process of opinions. Several of issues can be seen in the separation of the plenary sessions in only 4 times a year, and also the comments procedure, which can prolong the adoption procedure. I'm sure the Copenhagen dilemma was already mentioned, so that is the bystander between the old and the new democracies, but also the perception of the national judges, especially at the Constitutional Court, of the soft law of Venice Commission, which they really embrace in their decision, and also in some sort of way transport it in the hard law at the national level. Another issue of Venice Commission is the limited capacity of the Secretariat. As the Venice Commission is expanding also in number of countries and also in the workload, the Venice Commission Secretariat is for a long time overworked and is missing a substantial part of the analyst. And the one issue that was mentioned by the stakeholders the most was the over-reliance on the formality. So simplified, they did argue that even though the institutional framing of the judicial governance was transformed, the informal practices and social cultural development did took a different path of the functioning of judicial councils. So what would I advise in the next following up? So Venice Commission does created an amazing platform for discussion, is encompassing the most reliable experts in the field. Maybe should more focus on the empirical research, engage more with the political sciences, and also with the stakeholders and local experts. Just to quickly summarize how the ECtHR enjoyed the formation of the European model. The ECtHR was not for a long time commenting on the design of local judiciaries. That did really change with the expansion of the ECHR criteria, which interpreted the right to fair trial as a structural human right, which did lead up to individual judges submitting complaints and resulting in the new standards developed by ECtHR. So what I was expecting is that as the Venice Commission does have good mechanisms for developing the opinions, the ECtHR would, in the majority, use the opinions of the Venice Commission. That is more so true, yet we are seeing some divergences in the case of the ECtHR. I've highlighted some of the nuances, but I would, for example, mention the current situation in Poland, as though we are seeing that the Venice Commission is looking more so on the formal and structural side of the issue, and is preferring that judges should be reappointed only through proper procedure and annual procedure. The ECtHR has continuously mentioned in its decisions that even a single illegitimate appointed judge can invalidate the legality of the entire judicial formation, and that structurally compromised bodies undermine the court status as tribunal established by law. So we can discuss why there are some divergences between the findings of the Venice Commission and the ECtHR. I have 1 minute, I see. Most of them are coming from the basic functioning of the both Venice Commission and the ECtHR, which is obviously very different, as the Venice Commission is preparing the policies more on the abstract level and is working in a manner of research and then policy drafting. It is really different to the mechanism of the ECtHR, which is adjudicating the concrete cases and can look into more individual and context-related issues. For the discussion, then I'm bringing the findings from the previous interviews, and I'm curious how could the informal practices be reflected in the opinions both of the Venice Commission, not so much about the ECtHR, which cannot properly develop new policies. Also, I would shift my focus from solely focusing on the independence of Judicial Council and transfer it into the organizational resilience. And also, I would more focus on the individual independence of the members of the Judicial Council based on the principal agent relationship, which still has not been addressed either by the Venice Commission or either properly by the ECtHR. Yeah, thank you so much.
Thanks, Viktória, for discussing such a core issue related to the rule of law, judicial independence, and institutional. This is very often and rightly so connected to the role of judicial councils and judicial governments more generally. Let us then move to the next speaker, Dr. Dragoș Călin. He is judge at the Bucharest Court of Appeals. He also trains magistrates at the dedicated academy and is a researcher at the Romanian Academy. He co-founded and co-presides over the Romanian Judges Forum with a PhD in law that he earned in 2018. He has authored over 200 legal publications across Europe, the Americas, and Asia. More details in his bio that we have published on the website. Dr. Călin will present on, so the title of his presentation is Ricochet Efficiency, ? The Court of Justice of the European Union and the Real Valorization of the Opinions of the Venice Commission regarding the legislative changes on the Romanian's judicial system.
Thank you so much.
If there may be anyone who can share a helping hand. And even after 4 years of pandemic, we still cannot use Zoom. So.
From your local museum.
No.
Okay. Thank you.
Well, thank you. So I will start from the very beginning that I do not criticize the Council of Europe. On the contrary, probably the Council of Europe and European Union bodies are cooperating seriously to implement the opinions of the Venice Commission. And I want to thank Professor Anca Baielingai from Brno. She helped me a lot with some ideas regarding this subject. Well, in the case of Romania, in the period 2010-2017, hundreds of judges, prosecutors, members of the parliament, former prime minister, having committed to corruption. So it was a matter of corruption. And after that, it was an attack against the National Anti-Corruption Directorate since 2017. And the parliament voted some laws. They, in fact, destroyed the competence of the National Anti-Corruption Directorate, and they voted some new laws of judiciary, introducing some harmful amendments to the independence of judges, for example, limitation of the freedom of expression of judges, and some unacceptable provision on the material liability of judges and prosecutors. And the cream of the crop was the establishment of a new separate prosecution section created for the investigation of crimes committed by judges and prosecutors. In fact, they split the competencies of the National Anti-Corruption Directorate, and they create this special body. And in the last 8 years, we don't have any case of corruption in judiciary in Romania regarding judges and prosecutors. So it was a huge pressure of the international bodies like Venice Commission, like European Commission, Consultative Council of European Judges and others. But this kind of pressure was systematically suppressed because of the war in Ukraine and the help of Romanian government for Ukraine. From an historical point of view, as the Constitutional Court of Romania established frequently in its case law, the recommendation of the Venice Commission cannot remain without practical efficiency, without this amounting to breach of the principle of primacy of the Romanian Constitution. And we have a lot of decisions since 2010 2013, 2015. As a result, a case law that frequently used the opinion of the Venice Commission has been consolidated, and the Constitutional Court referred in that period many opinions of the Venice Commission, but it was not the case regarding the amendments of the laws of the judiciary in 2018, 2019, because the Constitutional Court changed the approach. They adopted a new approach, and the opinions of the Venice Commission does not constitute a question of constitutionality of the legislative acts thus adopted by, but a question of the appropriateness of adopting the criticized law. Thus, the recommendation made by the International Forum could have been only useful to the legislator and not for the Constitutional Court when the Constitutional Court analyzed the constitutionality of these provisions. And they use this kind of decisions since 2018, 17, 18, and the last one was in 2022. Is this decision 88 on March 9, 2022? They used this trend, and the opinions of the Venice Commission do not have constitutional relevance, but possibly constitute a support provided to the constitutional judge interpreting the reference constitutional text. In the case of Romania, the Venice Commission published several opinions. For example, this opinion 920 from 2028, recommending to Romanian authorities to remove the proposed limitation on judges and prosecutors' freedom of expression and to supplement the provision of magistrate by material liability. And another one, it was 950 on 2018. They criticized the new created section for investigation of criminal offenses in the judiciary, the special section in judiciary, and others opinions. But the first decision of the European Court of Justice was in May 18, 2021. Romanian Judges Forum Association and others, and the European Court of Justice criticized these legislative amendments in Romania that destroyed the independence of judiciary, and the court used the opinion of the Venice Commission. It was another judgment on December 21, 2021 in the case Eurobox Promotion and others. So we can say that it was a heavy circumstance, given that subsequently only the Parliamentary Assembly of the Council of Europe had the initiative to refer the matter to the Venice Commission, especially because of the request of Romanian Judges Forum Association. It was an ultima ratio. The last one was in 2022. It was a new draft law on the abolition of the special section for the investigation of offenses committed by the judiciary. And the Venice Commission recommends restoring the competencies of the National Anti-Corruption Directorates in Romania. And another one was in November 2022 regarding the new laws of the judiciary. In fact, the Romanian Parliament dismantled the special section, but they replaced the special section with a special network. So, in fact, we have the same prosecutors that are investigating the same judges and prosecutors. So, two prosecutors from the prosecution office attached to the High Court of Cassation and Justice must investigate around 800 judges, prosecutors of the Court of Appeals, High Court of Cassation and Justice, Anti-Mafia Office, National Anti-Corruption Directorate, and others. So it's impossible to do it. So in the last 8 years, we don't have any kind of corruption in judiciary investigated by this special network or by the special section. They dismantled the provisions regarding the material liability of judges, adopting, in fact, the proposal of the European Court of Justice, and they dismantled some of the provisions regarding the freedom of expression of judges and prosecutors. So, in fact, the Romanian Parliament used this judgment of European Court of Justice from May 18, 2021 to change a little bit the legislation. Because the Venice Commission reports were in fact not applied by the Romanian Parliament from 2018 to 2021. We have a problem with this special network, so the only change to change the special network and to restore the competencies of the National Anti-Corruption Directorate was using a new preliminary ruling at the European Court of Justice, and it was a ruling. It was a case 53/23. The same Romanian Judges Forum Association, Association de Magistrats, but the European Court of Justice did not answer to the second question due to the lack of interest of the Plaintiff Association of Judges and Prosecutors of the National Case File. But in its observation to the European Court of Justice, the European Commission referred to the concern expressed by the Venice Commission regarding the process of appointing designated prosecutors and the difficulties regarding the appointment of the prosecutors by the Superior Council of Magistracy to certain position, which led to discrepancies in terms of workload distribution. In fact, they try to understand and to put in practice this kind of restoring of the competencies of the National Anti-Corruption Directorate. In the case of Poland, it was the same. A lot of opinions, 892, 904, and but in the case of Poland, the European Commission has launched infringement procedures. In the case of Romania, they refused to launch infringement procedures, and in the case of Poland, the European Court of Justice pronounced many other judgments using the Venice Commission opinions. For example, it was a judgment on June 24, 2019. It was the case commission against Poland, Independence de la Cour suprême, and they applied some of the Venice Commission opinions. Another case was in July 15, 2021, Commission against Poland, Régime disciplinaire des juges. As a result of this anti-European attitude of the Constitutional Tribunal of Poland, practically the quickly form through which the opinions of the Venice Commission became effective here were the judgments of the European Court of Justice. It was not the case of Georgia, because Mariam talked about Georgia. In the case of Georgia, a lot of opinions. The last one was in 2024, I think. It was this 1190. But everything seems to depend on political will, circumstantial interest, and the shifting geopolitical landscape, because Georgia is not a part of the European Union, and the Court of Justice of the European Union cannot therefore come to the rescue of the effectiveness of the Venice Commission opinions, as it did in previous cases examined Romania and Poland. And no amendments were made following the adoption of these opinions, and there is no real and serious conversation to apply the opinions of the Venice Commission. But this situation, for example, in Georgia, has evolved in a worrying way. Indeed, it remains to be seen what contribution of violation ruling by the European Court of Human Rights will make to the issues addressed, and the effects of any other actions taken by the Council of Europe level. Of course, the judgments of the European Court of Human Rights are also binding, or at least provide legal guidance for Georgia. But this presentation does not want to demonstrate that there is no indirect effectiveness through the European Court of Human Rights and the system for monitoring the execution of its judgment. In fact, we welcome the progress made thanks to the combined efforts of the Council of Europe and European Union's bodies, even if there are still obstacles to overcome, and the importance of continuing to implement these synergies. And given that the judgment of the European Court of Justice had been issued more quickly, and there is the possibility of infringement procedures initiated by the European Commission in the case of non-compliance, including the application of financial sanctions, like in case of Poland, this system seems faster and more effective. This can be seen from this example presented. The real valorization of the opinion of the Venice Commission came quickly from the Court of Justice of the European Union, as the judgment issued in the request for preliminary ruling submitted by the Polish or the Romanian judges regarding the rule of law solidly relied on the contribution of the Venice Commission. In my vision, is Ricochet effectiveness indirect and yet binding, but it seems to be the quickly form in which the opinions of the Venice Commission can become useful in countries with slippages regarding independence of judiciary, at least regarding some general principles. In the case of Georgia, such a mechanism is not useful. The state is outside the European Union. The authoritarian tendency seems impossible to mitigate. But we must imagine Sisyphus happen. Thank you.
Thank you very much to all the speakers for their thoughts and considerations on the role of the Venice Commission. And I wanted to mention once again and thank the Venice Commission for sharing materials specifically dedicated to the for the anniversary and developed for on the occasion of the anniversary of the Venice Commission and also the European Convention on Human Rights. I will start with very brief questions to the panel, and then we will select some more questions from the audience. So, Kushtrim, as substitute member of the Venice Commission, I was wondering whether what your thoughts are on how the rule of law checklist could be awareness could be raised more on the rule of law checklist, but also its use. It could in terms of actors or tools or how it can be used more and make stakeholders more aware of this instrument. For Viktória and Dragoș, I was quite interested by your point on the power dynamics between Council of Europe institutions, Viktória, but it also connects to what Dragoș was saying. So we have, first of all, the power dynamics among Council of Europe institutions, so the Venice Commission and the Court, but also you added another layer, which is the European ECJ. So if you could share a few more thoughts on those dynamics and whether you have noticed from the research that you have done of any cases in which there is divergence rather than convergence, as you mainly covered in the presentations. So maybe questions from the floor?
Don't need the mic. I can just. Thank you. Very good. It was a very interesting set of complementary presentations. I actually have a transversal question, slightly provocative. So, obviously, I'm a big fan of the Venice Commission, but my question to you is, have you come across situations where actually opinions of the Venice Commission have made the situation worse by misdiagnosing, essentially providing possibly an inaccurate or half-accurate diagnosis of the situation, leading in fact to reforms who made the situation worse? I have some concrete examples in mind, but I would be interested to know perhaps if you have some specific example, especially in the case of Romania. Would you say that in this specific context, has the Venice Commission made the situation better? And I'm saying specifically regarding Romania because the EU Commission is now starting to ask member states, including Romania, to specifically implement Venice Commission opinions. So we better make sure that the Venice Commission does get the situation right. So thank you.
And I can just feed in a question from online from Aisha.
the European Court of Human Rights and the CJAU have used Venice Commission's opinion. Should the Commission, the European Commission, also be encouraged to use and implement Venice Commission opinions enforcing the rule of law across Europe?
I have Ed Bates, University of Leicester. My usual ignorant question, a question from ignorance, but I'm wondering about the Venice Commission and the approach it adopts when there may be a particularly controversial situation put before it. I have a limited knowledge of the Venice Commission and its opinions, but those I have read, the conclusions seem to be fairly objective, and sometimes I feel they're sort of pulling their punches, not as direct as they could be and critical as they could be. That may reflect the nature of the Venice Commission. It's not a prosecutor, and it needs to create cooperation in good faith. But so there's a general question I have there about that and your perceptions of that, and what might be done to improve the Venice Commission's approach or opinions. But of course, that question has to be tempered by the prospect that it's the Venice Commission's remit and job is as I just described, not to prosecute states, so to speak.
Unless you go back to the panel. If there are no other questions. Maybe.
My question is to Viktória.
Sorry, I switched it off.
Sure.
Your topic is very useful, and especially that you are also doing the empirical studies to understand the problem better. I was wondering to what extent you are also looking into suggestions of Venice Commission in terms of reforming the bodies. So I guess the Venice Commission is not completely giving up on this structure that we see, but for instance, voting procedures, whether it should be 2/3 or other kinds of, if it has suggestions, and whether the suggestions are actually consistent with, for instance, the guarantees that it gives to the members of the High Council of Justice, as we see also from ECHR now. Not only judges, but High Council of Justice members also have this protection from removability. So how consistent it is, or maybe it's outside of your scope, but it's really interesting to see that not only the appointment, but reforming is consistent with the standards that it already proposes.
Over to the speakers. I will maybe for ease of logistics, we'll start with Kushtrim.
Yes. Thank you. Very interesting and well, also provocative questions, which are of course always very welcome. I'll try to address in the same order as I heard the question. So on the awareness of the rule of law checklist and the Venice Commission, I would say in general, there is states, especially in Eastern Europe, know a lot about the Venice Commission. If you, not so much in the West, and sometimes we talk with colleagues that if you tell someone in the Eastern Europe that you work in the Venice Commission, it's seen as a very prestigious thing. Most people in the West don't know who their Venice Commission members are. And there is, of course, history behind that, but it shows, and people know a lot about the Venice Commission. I think many of us come from Southeast or Eastern Europe, and I believe we all share that viewpoint. Media, civil society, people in general know quite a lot about the Venice Commission, and they take the discussions very seriously. These issues are reported in news, what Venice Commission has said with regards to a given country. But I think there is not much. Venice Commission does operate partly as a kind of secret organization, in the sense that there is not much awareness that comes from the work of the Venice Commission. that they would do more advocacy, that they would try to reach out to people and different parties. So the knowledge about Venice Commission, in my view, has a lot more to do with histories of certain countries rather than the deliberate work done by the Venice Commission in this. And I remember a year ago, it was the Attorney General for England and Wales, and speaking about the rule of law backsliding, he said we should move from Scuola to the street. The Scuola is the name of the building where these meetings take place, the most pretentious building of an international institution, I would say, in Venice, and to actually communicate more. So I think there's a lot more that can be done there. On the European Commission, yes, they do refer a lot. Actually, the cases that were mentioned, this rule of law checklist, are very much because of the work of Commission. So does the EU Parliament. They do refer often to the Venice Commission opinions. On the misdiagnosing or worsening the situation, I think that's always the risk. And when I was appointed to the Venice Commission, I spent quite a lot of time trying to ask senior members, because some are members there for 20 years or more. And so it's a very responsible task, because sometimes states, as I said, they are not interested in actual opinion of the Venice Commission. They're interested in an approval from the Venice Commission. And so one of the tips that I got from one of these more experienced colleagues was to be very careful what you choose to address in the opinion, because they bring you a law, and if you engage with several issues, it may come across that they complied with 99% of the opinion, but not with 1%. But that's only that 1% that is crucial. Are judges independent? And what was that main issue there? So it's a very responsible task, and I don't exclude that there can be situations where things may not have gone as good as the intention was. But that's also a bit an answer to Viktória's about telling the alternatives. I think it's and connecting to Ed's comment, the work of the Venice Commission is not designed to tell one single model or to tell what alternatives could work, or to even criticize, I would say, the states. It's very often, even in speeches in the plenary, states are encouraged and appreciated for what they have done. And then very diplomatically, it's framed where areas for improvement are. It's very exceptional, like recently, with Georgia, that language has changed, or with regards to Hungary, Poland in the past, where there was it was naming and I wouldn't say shaming, but blaming for sure. So it's very carefully done. And I think that is a good side, in my view, because the Venice Commission should be seen as a complementary mechanism. And maybe also interesting to see whether this kind of diplomacy, in a way, works more than sometimes a judgment. So that I don't have a diagnosis for that, what is the better option. But I definitely think that such an institution is complementary. So I think I addressed the questions as far as I'm concerned. Yeah.
Regarding Professor Pesh question, yes, it was an opinion, 1105, November 18, 2022, regarding the new laws of the judiciary in Romania. And in fact, it was a collection of opinions of some participants of the dialogue, because the Venice Commission mentioned, this is paragraph 74, given that this is an urgent opinion, the Venice Commission cannot exclude that there are other issues in these three laws which may be problematic, but it seems that on the whole, the laws seems to be heading in the right direction. And the European Commission used this Venice Commission opinion to remove the cooperation verification mechanism. in the case of Romania. But this commission is not, this opinion is not complete, because the main problem of the new laws of the judiciary is the control of the president of the Court of Appeals regarding the judges from the Court of Appeals. For example, the president of the Court of Appeals control the promotion of judges from the regional tribunal to the Court of Appeal. They have many competencies regarding the evaluation of judges from the regional tribunal and the Court of Appeals. They put judges in the panels. They can change the judges' chamber from the criminal chamber to the labor law chamber, for example. So it's a lot of competencies, and this seems to be against independence of the judiciary. So in this case, probably the Venice Commission, it was probably, I don't know, maybe we need a new opinion of the Venice Commission regarding the laws of judiciary, but not an urgent opinion, analyzed and very analyzed opinion on the new laws of judiciary in Romania. Thank you.
Okay, so we have a list of questions. First of all, in terms of power dynamics between the Venice Commission and the ECtHR and potential.
Microphone, please.
Sorry?
Just put it a bit closer.
Yeah, sorry. Maybe I can take it into my hands. So in terms of power relations, I would say that by estimate, I would say that in 90% of the issues that create or are ruled by the Institute of Judicial Councils and Governance, it is the ECtHR did follow the Venice Commission opinions, yet we can still find here those 10% or 5% which can turn around the whole issue into a different level. So just to name some of the divergences of the ECtHR, as I already mentioned, the ECtHR does consider a judicial panel illegitimate, even if there is only one judge who was appointed not in line with the constitutional rules. Also, the ECtHR also look at the procedure of the appointment of judges, not only the formal bodies and how they were created and whether those were in lines with the Euro model, but also whether the process itself did not structurally compromise the appointment of judges. So the ECtHR has the privilege to take into account more of the contextual factors of each individual case, whereas the Venice Commission does create the opinions either generally or for individual countries, but cannot really address an individual issues in the design. So even like the mission and the basis and the operation between the bodies is really different, because Venice Commission is proactive, and even though it cannot start the opinion formation by itself, it can still manage how it will conduct its procedure of drafting the opinion. Who will be the reporter that is based on the on his experience? Who will be the stakeholders and the representatives of the state for which they will interview during the country visit? How long will be the country visit? They can use many more academic consultations, informal dialogues, and etc. Yet ECtHR doesn't have that big privilege with the engagement of the professionals in the field. Is deciding more so based on the law and the convention, and is in some sort of way constrict and deciding behind the closed door, whereas the Venice Commission can go into the field and engage with the local experts. The next question is what? Sorry. The misdiagnosed situation in the Venice Commission opinions. I would not be concrete about the individual opinions, but rather say that the Venice Commission did focus for a long time strictly on the isolation of the judicial councils, strictly from the political power, but did not pay enough attention that into the internal independence of the judicial council. So the independence from the judges themselves. The results of the judicial corporatism were the individual judges who wanted to take over the governance of judiciary. And even though this model was formally in line with the opinions and with the standards, informally for example, in Slovakia, Minister Harbin was misusing the whole setup of the Judicial Council just to strictly manage the development of judiciary by his preference. In terms of whether the opinions are direct enough and what can be done, as I said previously, from the interviews, it seems that the Venice Commission or the Secretariat does not have enough of contact list with the stakeholders. And it seems that even though the NGOs are publishing a lot of reports on the national level, there is some kind of communication boundary between the civil society and the Venice Commission Secretariat, or either also with the academics. I've seen the dialogue just as this with the academy only, let's say, in the several few years. Before that, it was more so closed by the judges and judges' preferences of the model they know, and they can rule. And in terms of diplomacy of the Venice Commission, this is a tricky one, because we've seen that the Venice Commission did change a bit of dynamics with the opinions in Hungary and Poland. And even though there is an idea that diplomacy can take you more far away than the sanctions and the formal rule following. Yet what we've seen, for example, with Slovakia is that even though the people who know the context of the recent changes in the criminal code or also in the constitution, they could have read the issues that the Venice Commission was stating in the opinions. Yet, as it was so diplomatic, the Prime Minister of Slovakia, Mr. Fico, was stating that Venice Commission even appraised the changes. I think that if the Venice Commission would be more concrete, it cannot really hurt the thing, because pointing at the issues which are present does not mean closing the dialogue. So there are other institutes which are then aspiring more formal rules and procedures with the inconsistencies. So.
Thank you. Are there any questions? Although mindful of time, we are approaching, so we are 5 minutes over the scheduled time, which is great. Thanks very much for staying with us, for participating in the discussion. And let us thank once again the panelists for their engaging presentations and discussions. So thanks.